I just ask you, because it does seem to me that the core of this is how we characterize Yearsley. Is it a defense or is it actually conferring immunity? What do we do with the fact that in Yearsley itself, the government had waived sovereign immunity? That's my understanding. And so to the extent that's the case, wouldn't we have a very odd scenario in which the contractor would somehow be given immunity, but the government itself wouldn't, even though you say the contractor's immunity is derivative of the government's?
This illustrates exactly the way it's supposed to work.
Okay.
So the sovereign waives its immunity in that case and accepts liability, as it must constitutionally for a taking, by the way.
Right.
But then you sue the federal government. Our friends on the other side haven't sued the federal government in this case. The whole game here is suing contractors to try and thwart the government's policies. And so, today it's a case about immigration detention. Tomorrow it could be Cunningham, in which the contractor was engaged in signing people up for subsidized insurance under the Affordable Care Act. If you name a government policy or program, it will rely on contractors, and I can find you somebody who would like to stymie the implementation of that program. So that is how we get back to the important interests at stake here. But to Your Honor's question, the government is free to waive its immunity all it wants. The question, however, under the common law, and the long common law tradition, is that when contractors are performing as directed, that they are immune. And that makes sense. I mean, you should actually want to focus the litigation on the decision maker.
No, I understand, but you can do that by treating it as a defense. It's just odd to suggest that in a derivative sovereign immunity that there is derivative sovereign immunity in this kind of circumstance. I mean, yes, to the extent that the contractor is saying we were just following orders, the law provides an opportunity for them to defend themselves as a result of that, and I thought that's really the crux of what Yearsley is getting at. But as Justice Kagan said, that's a different concept than we should be liable, we are liable, but we are not going to be held liable because we have immunity.
It is a different concept, Justice Jackson, and it's an importantly different concept because qualified immunity could be a defense.
No, but it's an odd concept in a world in which the government has assumed liability.
So sometimes it has
scenario.
Sometimes it has and sometimes it hasn't. In this case, the government has not waived its sovereign immunity as to the administration of these programs, which is why they've sued us. The government runs the exact same programs at its facilities. It's Section 5.8 of the PBNDS, which is the voluntary work program. Congress appropriates exactly the stipend that GEO pays. It's at PEDAP 141 and 144 is the disciplinary scale that comes from the government. It applies to their facilities too. So all of these decisions are made by the government, which is why I think Your Honor makes a good point that the suit should be directed against the government.